the first part of today's annual Extractives Baraza is really dedicated to the young people. And the idea is, let us create platforms where they can build their skills, showcase their skills. This is also networking. I can't tell you how many requests we get on a monthly basis about, do you have an intern? Can you send me interns? This is where, ladies and gentlemen, you'll get your interns. Because these young people have prepared intensely and have made it to the finale. And for that, we are absolutely thankful and grateful.
Basically, as Extractives Baraza, we have started as an institution that try to create credible information in order to enable citizen participation and engagement in the governance of extractive sector in Kenya. In this regard, Extractives Baraza basically focuses on non-renewable natural resources. Not renewable, but non-renewable natural resources. And therefore, our aim was to engage citizens in terms of policy dialogue and also engagement with regard to governance issues around the extractive sector. Our mission generally has been to provide high-quality research information to the citizens in a dynamic and knowledge that allows research, content generation, training, and partnership. That is what we have been working on. And basically, as a steering committee for the Extractives Baraza, our main task has been to oversee and also provide guidance in terms of strategic and actions that are going to inform the process of engaging citizens in terms of what needs to be done in order to realize effective and confident way of relaying information for the citizens with regard to Extractives Baraza. In that process, we have also been effective in providing overall guidance and outcomes that are competitive to our ideas. In terms of Extractives Baraza, there are also other players in the sector. Our main attempt has been to look at what are some of the barriers in Extractives Baraza. How can we make Extractives Baraza more competitive in terms of other institutions that aim to provide similar information that are of key interest to us. In this brief presentation, I'd like to take you through what Extractives Baraza has been doing using three main issues. What, and now what? Basically, we're trying to do what was the idea behind Extractives Baraza. Once we have established the challenge, what are the solutions way forward in terms of the gaps that Extractives Baraza tried to provide? And once we have been able to do that, we will not be successful unless and until we have been able to provide benefits for what we have been doing over the last 1 or so years. In terms of challenges, where action have been informed by limited access to information. And that was one of the key issues or gaps that informed the creation of Extractives Baraza. There is a lot of information about Extractives Baraza. They are not consolidated in a systematic and reliable way that citizens can access. The information dissemination was also not consolidated, both from government entities and international oil and gas companies and also mining companies. Therefore, the information was not centralized in a way that users can access information from one central portal. And Extractives Baraza was guided by this gap in information needs that motivated the creation of Extractives Baraza. And that was one of the key aspects or gaps that informed Extractives Baraza. Over the last 1 year, we have made tremendous improvement and engagement with stakeholders to inform different stakeholders what Extractives Baraza is all about, both communities, civil society, companies, investors, and government, why we want to do things the way we want to do in a credible and reliable way. We have managed to engage multi-sector advocacy neutral public forums in different instances where we thought there was a need to engage the public. Therefore, the creation or launch of Extractives Baraza was unparalleled in Kenya. It did not exist in East Africa region. Therefore, we need to laud Extractives Baraza for the achievements made so far. Our achievements are basically focused around three main areas. Around local content development in terms of international oil companies or mining companies what are some of the key issues or benefits that the local community should expect from what is done in Extractives Baraza. The other aspect, which is also enshrined in our constitution, is public participation. How do we engage public in the issues around Extractives Baraza? The main idea behind public participation was some of the key risks issues around Extractives Baraza in terms of resource scarce issues, that regions or countries that have discovered extractive resources, those resources have turned out to be a curse as opposed to blessing. One way that we can undermine that option is to engage the public in a forum that will play equal role in informing information and allow benefits flows in a consensus manner. And the third aspect has been the issues around transparency and accountability. The moment, for example, that Salwa discovered oil in Turkana, one of the perceptions was it appeared as if the oil will flow the following day and revenue will start flowing to Turkana and the country immediately. That's not the position. Therefore, there's lag in revenue generation, and therefore the public need to know the issues around revenue and the process that leads to revenue creation in the extractive sector. So those are the areas that we have been engaged in and provide a solution through different forums. And now in terms of now what, the benefit option, Extractives Baraza has three main activity tracker, as we call it, and also key stream areas: inform, connect, and transform. Issues of inform, which is one of the key activity trackers under extractive sector, we have been able to realize over 200% increase in the traffic flows in the website by the users during the first and fourth quarter of last year. That shows a tremendous improvement and engagement of the Extractives Baraza with stakeholders. The second component of Extractives Baraza, which is one of the key core values, is to connect. Connect has different meaning when you talk about internet and connectivity today. People could be in the same location, but they could not be engaged because of internet connection. Two persons, you see, engaged in internet are distanced when it comes to connection. One is talking to a friend or relative in US through internet, and now is talking to someone in Canada. Therefore, connectivity in that sense raises issue, and we are so much aware through Extractives Baraza these issues exist. Therefore, through connection, through Connect, we have been able to engage extractive sector forum, quarterly fireside chats where we invite interested and like-minded players to engage us, Kenya local content with exchange in the counties, and what Dr. have described as raise challenge, and also engagement with energy for I, among other connection options. And finally, one of them that we have been to do was to transform. Our transform activity has taken three main aspects. One is through sessions that have been organized. Two is through users that we have observed through website. And third one is web page view. All these have been tracked over the last 1 year, and we have seen tremendous increase in terms of transforming how these different categories of users engage extractive sector internet portal. Therefore, I can confidently say, in terms of the Extractives achievement today, we have realized improved access and dissemination of information through the portal, formation of extractive policy working group that is coming for the next year, enhanced dialogue across different sector players, and local content exchanges with diverse key players in the extractive sector in Kenya. Now, setting the platform for today and moving forward, I can say that Extractives Baraza has made tremendous milestones, and more importantly, it is in future that our power lies. The future of Extractives Baraza depends on what we do in the present. In other words, every move we make, every action we take in the present is for us a stepping stone in shaping how the Extractives Baraza will look like. It is my sincere hope that the achievements so far made has been tremendous, and I think we need to move forward in terms of what and where the Extractives Baraza will be. And finally, in as far as the issues around Extractives Baraza are concerned, and also to speaking to the participants today, the time to do things right is now, and therefore information, connection, and transforming citizens' participation and engagement in the governance of the Extractives Baraza in our country, within and without the outside the Extractives Baraza portal, I think is our key role moving forward. Thank you very much.
First and foremost, I take this opportunity to thank and congratulate Strathmore University, and in particular the Extractives Baraza, for hosting this annual conference and successfully hosting the moot court. I think we're just going to see what is happening, and I'm very glad to have Professor Joan here. I was a student of his more than 20 years ago, constitutional law, and I'm very glad he was my teacher. So I think he's going to help us right through on this particular issue. And I guess this competition has provided the competing teams with an opportunity to delve into the intricate issues that we're dealing with in the world of extractives, and in the process create an opportunity for them to understand the complex underlying issues, especially the legal issues. I was looking at the moot court question, and I was saying, thank God I'm not in school right now. But I think, when you have many people together, it creates a sense of, I think you're able to think and come up with something. So I'm really looking forward to see the simulation. So just quickly, I think Dr. Wario, when he was talking about the extractive industries, he picked out quite a number of issues, so I shall not belabor the points. So I'll just basically say that the promulgation of the Constitution of Kenya in 2020 ushered in a new political and constitutional dispensation, and then being a very progressive constitution, it has basically taken cognizance of the issue of the importance of the natural resources and made remarkable provisions, which I think we need to have very specific laws to ensure that we actualize these particular provisions. This has coincided with the commercial discovery at the Turkana County in the northern Kenya. The discoveries were positively received with the hope that the country would become secure, and which would in turn help us achieve our aspirations in our very nice elaborate blueprint, Vision 2030. This basically requires a good legal and regulatory framework and awareness creation, which I think the Extractives Baraza is doing a very good job on that. So there's a very strict timeline that the Constitution of Kenya has provided within which we need to enact this particular legislation in relation to the natural resources. So basically, the draft petroleum bill and the energy bill are currently pending in Parliament, so we hope they'll give them priority. We know the way Parliament operates, so we need to be able to push. So Dr. Wario, I'm sure that is one of the priorities from Treasury and also from the Office of the Attorney General. The bills have made elaborate provisions which aim at improving the lives of the people of Kenya, such as the local content, which Dr. Wario has spoken about, requirements on capacity building and transfer of knowledge, revenue sharing from oil sources, resources between the national and county governments. I'm sure that can be quite a thorny issue. When you're looking at the moot court competition, I think they concentrated a lot on the transboundary issues. I don't know whether you're looking at transboundary in terms of nations as transboundary. So they're all, you can look at it transboundary within the national borders and transboundary outside, internationally. So those are some of the things that we find very interesting. Other progressive provisions include the Sovereign Wealth Fund, I'm sure you're all aware of that, which would ensure that the revenue generated from the oil resources are secured in order to benefit the current and future generations. So basically progress is being made in the commercialization of these particular resources, which includes the construction of the crude oil pipeline from Lokichar to Lamu. And I'm sure there are quite a number of environmental concerns if you're talking about sustainable exploration of oil. And these are some of the things that the energy bill and the petroleum bill seek to address. And at the same time, if you're talking about the environment, there are certain issues that I think we need to ring fence
within the environmental laws to ensure that we do not have the issues, for instance, issues of spillage or, all those controversial issues for all of you who've been following oil exploration and extraction in different countries, and see how we can mitigate and reduce these particular risks. So, as I said, that the exploration and exploitation of natural resources is not without its challenges, which could be at both national level or transboundary. And as I said, we've talked about the environmental concern. Expertise in the area from within, in this particular area, is quite limited. And I'm sure Strathmore, by virtue of the fact that they've introduced their master's program, will bear witness to that particular fact. So we need to increase the expertise, both legal, policy, so that we can be able to move forward. So there is need to create capacity and awareness in relation to the impact of oil and gas exploration on the environment, which will inform the formulation of laws or amendment of existing laws to ensure that exploitation is sustainable without an adverse impact on the environment. So quickly in the field of mining, the government through the Ministry of Mining has taken a step towards enacting the Mining Act with the aim of securing the mineral benefits for the people of Kenya. The government is aimed at reviewing royalties, fees, taxation for mining companies in order to align them with the requirement of the Constitution. I know basically the Extractives Baraza, this particular, the annual conference is focusing mainly on oil and gas. So that was just by the way, to make you know that we are not just concentrating on one area, there are other areas that the government is looking into. Despite these new developments, our country is yet to develop its capacity in order to fully develop the extractives industry, especially in the oil and gas sector, as this is basically seen as a new sector. This has attracted collaborative partners such as the World Bank, and I think like right now within the Office of the Attorney General and the Ministry of Energy, there's the Kenya Petroleum Technical Assistance Program, better known as KEPTAP, which is basically aimed at building capacity, and it's basically over a period of time. It ends in 2022. The participants of the Extractives Baraza Court will agree with me that these are challenges that are real and require clear policies, effective laws, and dynamic institutions to address them at all levels. In order for the extractive industry to be well managed, the government and other stakeholders need to encourage the actors to be trained in order to gain the requisite skills, and this competition, as well as the LLM and the Extractive Baraza, we believe will go a long way in creating this capacity. The Office of the Attorney General is glad that the Strathmore University has taken a broad step towards building capacity in the extractives industry. The Extractives Baraza, as described by Dr. Suna and Dr. Mario, you can see I was editing this thing when I was sitting here, earlier on, provides a dynamic forum for discussion and facilitation of the growth of the industry. Other institutions of higher learning are encouraged to follow suit through collaboration with international institutions which have the requisite capacity. It is our hope that the objectives of this event, namely the creation of awareness on impact of the oil and gas exploration on the environment and the transboundary oil and gas results, and highlighting the complex and yet important nature of the gas and oil industry have been achieved. With those very few remarks, on behalf of the Attorney General, I declare the Kenya Annual Extractive
untapped reservoirs of oil within the shared continental shelf of this Southern Sea, and have begun exploration for the same, including conducting seismic activities, which have led to some adverse environmental effects, as well as an oil spill, as you can imagine, which have also led to some effects to the economic activities of the coastal states. These are coastal states. So the state of Sarkodia has taken Himia to the ICJ to answer for some environmental responsibility and liability issues. Just a quick briefing on the judges. Judges, both applicant and respondent have 30 minutes each. They will introduce themselves, their names, and give us a rundown of the time that they will use. Applicants begin, and judges, you're most free to ask questions. Feel free to interrupt the applicants, the counsels.
And their particulars. Maybe we start from this side.
Your Excellencies, it's a great honor for the respondent to appear before this honorable court. I am Chitindi Marvelous. Appearing with me is Agent Swale Hemed Wengo. Chitindi Marvelous.
Excuse me, which country would you be representing?
We're representing the respondent state of Himia.
Himia.
If it pleases this court, Kukebe Kevin is my name. I appear alongside my co-agent, Eva Maria. Your Excellencies, we represent the applicant state, the state of Sokovia. Thank you, Your Excellencies. We get started with the counsel for the applicants. Please proceed. Thank you, Your Excellencies. Good morning. For the record, once again, Kokebi Kevin is my name. Your Excellencies, I, alongside Eva Maria, do represent the applicant state. Your Excellencies, in regard to allocation of time, I'll be spending the first 14 minutes to argue the first two issues in our memorial. That is, whether this honorable court has jurisdiction to hear this matter and entertain it for that purpose. The second issue that I'll be tackling is whether the state of Himia is liable for the effects of the exploration activities that has taken place in their jurisdiction, and specifically the deaths of the sea turtles, the hawksbill-tipped sea turtles. Your Excellency, the last two issues in which my colleague will be spending the next 10 minutes to tackle is whether the agreement between the state of Himia, that's the respondent state, and that of Nabotia, the agreement that they have, the unitization agreement, whether it's valid. Your Excellencies, the last issue will be on the issue of reparation, compensation. Your Excellencies, if that explains the nature of submissions, I beg to proceed with your kind permission. The last 6 minutes we'll be preserving for rebuttals. Your Excellencies, what is before you today is an issue of jurisdiction, yes. But before we answer to the question on jurisdiction, the clarion call that not only is called to this court, but equally to the general state members around the globe, is the question on security to the ecosystem, ecological security. Your Excellencies, if I lay it bare as it should be, should a state, civilized so to speak, proceed on a path of self-destruction? Should that be the case? Your Excellencies, not only for its nationals, but equally to its neighboring states. The question that was asked to the young lawyer, what is the duty to your neighbor? Who is this neighbor that you're talking about? It is the applicant state. And we have suffered adversely from the actions of the respondent company, state-owned company that has proceeded with the extraction process. Your Excellencies, these are not my words. These are words by your very good brother, and justice for humanity are sitting there. Then it was a dissenting opinion, but over time, it has gained efficacy. Your Excellencies, in his dissenting opinion, in the adversary opinion, in the threat and the legality of use of nuclear weapons, then he said that the state should not set on a path of self-destruction. This very position was subsequently echoed in 2010 in the partner's case. Why then should the respondent be left to run on a flooring to set us, not only the nationals, but equally the applicant state, in a path that is self-destroying? That said, Your Excellencies, being my opening remark, does this court have the jurisdiction? It is the applicant's case and submission, and we'll be inviting this court to find as such that indeed this court has jurisdiction. The question on jurisdiction, Your Excellencies, is not a question of fact. It is a legal question. It is sacrosanct, and one cannot will facts to wield away the jurisdiction of this court. Your Excellencies, Article 36 of the ICJ statute gives this court the mandate on what it can handle. Article 36, Your Excellencies, and I'll only speak to two limbs of that particular article. That is Article 36, paragraphs 2. Your Excellencies, in that article, the question that I asked is one, has there been an international obligation which has been breached, which then calls for this court's action? There has been one. And we'll be proceeding to do exactly to show this court that there has been an obligation, an international obligation, which has been breached. The next question is on reparation. Your Excellencies, my co-agent will be talking on the concept of polluter pay. That is equally before this court. Your Excellencies, the main convention then that is in contention today is the Convention of Biological Diversity. Article 1 on the Convention of Biological Diversity speaks to the objective of that very convention. What is then the objective? The objective is preservation of the ecosystem. That is the very reason why you're before this court, and you're asking this court, should the respondent state then set us on a self-destructive path? Your Excellencies, Article 2 of the Convention of Biological Diversity then defines what is biological diversity. It is at various issues. One, the very Sydney Sea that we're talking about forms the biological diversity. The hawksbill turtles, sad to say, the 9 hawksbill turtles, in which are the beauty of that very sea. Your Excellencies, from the fact pattern, specifically, if you look at the fact pattern, Your Excellencies, and that is fact paragraph 2, there are 2. Your Excellencies, you learn that the applicant state, that is Sokovia, heavily relies on tourism as its economic backbone. And the death of those sea turtles is defined as being catastrophic, as per paragraph, that is paragraph 12, if I'm not wrong, Your Excellency, of the fact pattern. Does this court have jurisdiction? That's a question that we'll be still asking. Yes, it does. Having looked at the objective of the CPD, having looked at the definition of biological diversity, and when you look further into Article 27, Your Excellency, paragraph 3, when is this court then invited to adjudicate on a matter? This court is called on to adjudicate on a matter when the parties before you today have tried to solve this matter in another sphere or in another platform. Have they done that? Your Excellencies, it is the applicant's submission that that has been done, and that can be attested to having a look at paragraph 16. There has been negotiations which have failed. Your Excellencies, besides that, the respondent continues in her exploration. An exploration that when you look at paragraphs 11, 12, Your Excellencies, you will learn that there was an explosion, and from that particular explosion, Your Excellencies, there has been a spillage following the Sparrow Jack oil ridge. That was a wildcat that was being drilled by the respondent state under a state-owned corporation. Why are we before this court? We are before this court for the fear of what has so far happened. Your Excellencies, in the Kofu Channels case, if I may, the question on jurisdiction was again discussed. When does this court have jurisdiction? And how do parties then consent to it? Your Excellencies, one thing that comes out clear from the Kofu Channels case, that is between the state of the United Kingdom versus the state of Albania. The International Court of Justice, that is 1948, stated then that member states need not express consent to the court jurisdiction in advance or in any particular form. Your Excellencies, at paragraphs 1, both the respondent state and the applicant state are party to the CPT and have acceded to the jurisdiction of this court. They will be arguing, Your Excellencies, that without the state of Nabotia, then this court has the jurisdiction. We argue not.
Sir, excuse me, may I pause you then?
Yes, Your Excellency.
So my question to you will be, why do you think the Republic of Nabotia shouldn't be joined in this matter to begin with?
Thank you, Your Excellency, for the question. Why does the applicant state feel that the state of Nabotia is not necessarily party herein? The acts that have caused us to come before this court, Your Excellency, looking at, that is paragraph 11, Your Excellency, the acts that were committed by the respondent state. That is number one. And by its own national corporation. Where were they committed? In their own exclusive economic zone. Where was it committed? 3 kilometers away from our economic zone. That is our client. Your Excellencies, can it be said then that we should be joining a state that is not before this party? It will be sad to litigate for a party that is not before us, Your Excellencies. The acts solely were in the jurisdiction of the respondent state.
Okay, a follow-up question would be then, why was the Republic of Nabotia involved in the dispute resolution?
They will be arguing, Your Excellencies, that there is a unitization agreement to which the state of Himia and Nabotia entered into so far as exploration is concerned. That unitization agreement is a bilateral agreement between Nabotia and Himia. We are not party to that. And that is why we are not willing to invoke the same. In any case, Your Excellencies, we will only be invoking that if we were party to it. We are not. Secondly, Your Excellencies, in that unitization agreement, the question that is before this court, and probably will be asking, what is the shared resource between the applicant state and the respondent state? The shared resource is the Sydney Sea, not the proceeds of the exploration. The proceeds will be solely between, the sharing of the proceeds is between Nabotia and Himia. And that is why it is sad that we don't want to discuss and litigate on behalf of a state not before this court. Your Excellencies, in any case, be as it may, that this court finds otherwise, which we beg this court not to find so, because we have set on a path of self-destruction. Should we continue in that process? Simply because this respondent state has a right to develop. Your Excellencies, that question will be answered shortly. That said, Your Excellency, we urge this court and invite this court to find that it has jurisdiction to entertain this matter without enjoining the state of Nabotia. If the respondent feels that indeed they are slapped with sanctions to pay for the reparations and feel that Nabotia should help them, that is their private agreement. and is also expressed by the unitization agreement. So they can pay for what this court will find, then they can seek on how to sort out that as between Abotia and the state of Himia. Your Excellencies, that pushes me to the next issue. Your Excellencies, did the respondent state do due diligence? Was there an obligation that has been breached? Yes, there was an obligation that was breached. Your Excellencies, take cognizance of paragraph 11, where we state that the acts of exploration are only 3 kilometers away from the applicant state. Take cognizance again, Your Excellencies, that it is on a shared resource, natural resource. Cognizance again should be taken to the fact that the applicant state, just as the respondent state, rests their economic backbone on tourism. They're only trying to advance the economic muscle. But then should we continue that very path? If already their acts is already having a diverse effect to the environment. Your Excellencies, in the 12 smelters case, the question of transboundary harm kicks in. Was it foreseen, could it be foreseen that indeed the 3 kilometers variance was just close that will then probably lead to the respondent thinking that there might be an issue of transboundary harm? In the 12 semester case, the question is answered that if it is foreseeable, then you have to take actions to prevent the same. There was an obligation, Your Excellencies, not only to their nations, but equally to the applicant state. Your Excellencies, the effects of pollution we cannot come back from it easily. It will take us time. We can just suppose that with the recent spillage, the BP spillage, the Gulf, what has happened? To date, we still feel its effect. And the same effect is seen when we talk of the 9 turtles having been found dead. That is a fact pattern paragraph 13. Your Excellencies, in the Gapsikovo case, Judge Huber states that, and following Article 13 on the wrongful acts of state, on the Convention on Wrongful Acts of a State, he says that an obligation will arise if a state is party to the convention. Is the respondent state party to the convention? Yes, it's party to the CBD. Is there an obligation raised? There is an obligation. To that end, their continued exploration and the subsequent oil spill indeed then calls for that obligation. Your Excellencies, they will be arguing that there was no need to conduct an environmental impact assessment. And they will be telling this court that there was somehow an environmental impact assessment that was conducted, but then it was not thorough. Your Excellencies, we are talking about generations today and generations after. Should we then allow negligence to take and drive the cause of development? Your Excellencies, once again, in the case of Gapsikovo and in the Passman's case, the position is let us balance. We know and understand that they have a right. They'll be invoking the CBD. That is the Convention on Biological Diversity, that they have a right to develop. But when does that right become, is that right absolute? Then we'll not be having a Sydney to talk about. Then we'll not be having a state of Himia to even talk about. Not only is the state of Himia, but even the applicant state. Your Excellencies, may I invoke the emotions of this court. I know that emotions have no place in law. But then, what if that is the sole thing that anchors our very existence? Your Excellencies, the principles of environmental law have grown leaps and bounds, and now they're treated as part of customary international law. To that end, the respondent state is liable and should indeed be found to be liable. This court, we pray, has jurisdiction.
Thank you very much. May I draw your attention to paragraph 15
Yes, Your
of the
Excellency.
submission? I quote, the unitization agreement signed on the 5th of December 2014 between the states of Nabutia and Imaya duly qualifies that damages and liability shall be shared between the two contracting parties in the event of an oil spill or damage of a transboundary nature.
Yes.
So, does that not follow that those two parties, based on that agreement, ought to be joined before this honorable court?
Thank you, Your Excellencies. No, they shouldn't be joined. Why do we proceed on that trajectory, Your Excellency? There are two parties to an agreement which we are not privy to. That's number one. So we cannot even purport to proceed and litigate on an agreement that we are not privy to. That's one. Two, Your Excellencies, is that as they act in the unitization agreement, they act as agent and principal of the other. And from where we stand as the applicant state, Your Excellencies, and probably if you allow me to analogize, we know not the extent of who has the largest share of the oil exploration. That can only be told by an expert, and I not want to submit from the bar. And Your Excellency, that said, it might be the state of Himia, it might be the state of Nabotia, but our sole concern goes to where was the locus? The locus was in the respondent state, and that is why we opt to go for the respondent state, because that is where the actions occurred. And if the respondent state feel that indeed the other party, that is Nabotia, should be before this court, Your Excellencies, that is an issue of a third party, of which they'll be seeking indemnity. We don't seek indemnity, Your Excellency, from our point of view.
We're asking for reparation.
We're asking for reparation from the respondent states where the acts actually occurred. It did not occur in Nabotia. The actions were within the jurisdiction of the respondent state. Your Excellencies, if there will be no any other further questions from the bench, I can see the President of the court indicating that probably there will be something from that end. Thank you very much, Mr. President, and Your Excellencies. That will be the end of my submission until I come to rebut. If there are any, I'll seek to yield the floor to my co-agent.
Please proceed.
Good morning once again, Your Excellencies. As my co-agent earlier introduced me, my name is Eva Maria Anyango. And for purposes of my submissions, I will be addressing you on the third and the fourth issue, being whether the unitization agreement between the respondent state and Nabotia is valid, and finally on matters concerning compensation. I will start on the validity of the agreement. Your Excellencies, we do humbly submit that the oil spill that occurred as a result of the exploitation activities of the respondents under the unitization agreement amounts to a gross violation of international environmental law, which is the obligation not to cause transboundary harm. And for that reason, any activities under the unitization agreement should be suspended and not carried out anymore. As Counsel, my colleague earlier said, and I will reiterate, we do acknowledge, and the respondents rightfully can argue, that they have a right to development. However, this right is not absolute. It has to be balanced with their obligations under international environmental law to ensure that they do not cause transboundary harm. Our point of reference is Article 194 of the United Nations Convention on the Law of the Sea. It lays down the principle of the obligation not to cause transboundary harm. This is a principle that has also been adopted in decisions of arbitral tribunals, international arbitral tribunals, and the International Court of Justice. And in particular, I would like to point out the decision of the arbitral tribunal in the Trail Smelter case, which was between the United States and Canada. When you look at facts of this case, they do present similar situation as the one that we have before you today. Just like in that case, we had two states. We had the state of Canada, in which a company was emitting gases that polluted the environment and went even into the boundaries of the United States. And as a result, the United States sought reparations for the damages that occurred subsequently. And so in this case, we also have a state in whose territory there is exploitation activities that resulted in a catastrophic oil spill, which has affected us directly and has therefore caused transboundary harm. And so we do invite this court to find that the oil spill, which is a consequence of their exploitation activities, was a violation of their obligation not to cause transboundary harm. Your Excellencies, the oil spill has also violated the obligation to observe the precautionary principle, which is enshrined in Principle 15